Day 3 and the last day of the West Courtroom panel with Judges Clement and Elrod. We have two cases for oral argument today. The first case we call up, we'll be hearing here in the courtroom. The second case, for some logistical reasons, we'll be doing it by video conference. So once we complete the first case, the panel will stand in a brief recess. We'll reconvene upstairs via Zoom, finish that case, and that will then complete the docket for the week, and then all the cases will be submitted. So, first case up, number 21-60426, Exela versus NLRB. Mr. Schudroff, how do you pronounce it? Okay, all right, thank you, sir.
Should I adjust the microphone up or?
Well, generally speaking, if you keep your voice up good and loud, they're positioned to where they'll pick your voice off. I try to take cues off counsel at table and otherwise if people can't hear you. But if you just speak up, it'll get you.
Yes, Your Honor, thank you. And I respectfully request 5 minutes for rebuttal.
Okay.
May it please the court. The employer's petition for review should be granted and the board's cross-application for enforcement should be denied. The board improperly failed to sustain 2 meritorious election objections to the March 29, 2019 election, which the union won by an 8-6 margin. I will speak to the underlying merits of the objections momentarily, but the board should have found that the union's conduct, through its agents, destroyed laboratory conditions necessary for a free and fair election. As a threshold matter, however, Your Honors, the board's May 3, 2021 order is invalid because the underlying complaint in this unfair labor practice proceeding was improperly issued. On January 20th, 2021, President Biden improperly removed then Board General Counsel Peter Robb from office. As a result of this improper removal, the ensuing complaint in this case was issued ultra vires. The board did not address this issue below. Your Honors,
get to that real quick. Why? What makes you believe that the General Counsel has removal protections? Because there are no removal protections in the text, and in the related officer there are removal protections. So you could say the absence of one means that this person wasn't intended to have removal protections by the plain text.
Yes, Judge Elrod. The removal protections are found in Section 3D of the Act, which state that there shall be a General Counsel of the Board who shall be appointed by the President by and with the advice and consent of the Senate for a term of 4 years. So it's the 4-year, the shall that precedes the 4 years that Exela submits is
the term. So
term.
The idea is that no one can be removed before their term without proper procedures?
That is my client's position, correct.
Okay.
And if Congress wanted to include removal provisions in that statute into Section 3D, it would have done so. A little context is also helpful here. Never before had, since the 1947 amendments to the National Labor Relations Act, had a president terminated a sitting general counsel. In recent history, President Trump had permitted then General Counsel Richard Griffin to conclude his term, and even though he had been appointed by President Obama, and President Obama had permitted General Counsel Meisberg to continue and fulfill his term, even though General Counsel Meisberg had been appointed by President Bush. By contrast, President Biden waited less than a day to terminate General Counsel Robb.
To what effect, if any, does the ratification have on this case?
So, Your Honor, the ratification by Ms. Abruzzo, who's the present General Counsel, occurred, I believe, in the late July of 2021, after the board's May 3, 2021 decision. So Exela submits that there is no effect of the ratification by General Counsel Abruzzo to this present case, and that the ratification has no effect. And also, it's not part of the record before Your Honors. The board is a quasi-judicial body. For the board to fulfill its duties, its general counsel has to be able to disagree with the president. That is because, as noted in the Supreme Court's decision in Humphrey's Executor, quote, one who holds his office only during the pleasure of another cannot be depended upon to maintain an attitude of independence against the latter's will, close quote. A recent example is illustrative. In 2017, the Supreme Court reviewed this court's decision in Murphy Oil. At oral argument, General Counsel Mr. Richard Griffin argued the board's position, even though that position was at odds with the Trump administration's, which was then argued by the then U.S. Solicitor General. There was faith in independence in that case, and that is why the General Counsel should not have been removed in this case. The General Counsel is inextricably tied to the board members themselves as well. Critically, in the unfair labor practice context, like the present case, the board members cannot act until the General Counsel authorizes the issuance of a complaint. And the General Counsel is responsible for defending board orders, as is the case here today. Given this link between the General Counsel and the board, in the alternative, at the very least, the General Counsel should be afforded the same removal protections as board members have pursuant to Section 3A of the Act, which are for neglect of duty and malfeasance. And that may go to your point, Judge Elrod, before, about Section 3A and 3D working in tandem in that sense. Turning to the merits of the underlying unfair labor practice, which pertain to the election objections, just 1 hour prior to when the polls opened, an eligible voter, observed a shop steward for another on-site employer by the name of Fred Johnson, huddled with 3 eligible voters. Given Mr. Johnson's shop steward role with the union, this conduct violated the board's well-established peerless plywood rule, prohibiting election speeches fewer than 24 hours prior to the opening of an election.
How do you know it's an election speech?
So, Your Honor, we do not know whether or not what the content of the speech was.
I mean, they could have been talking about football or the lottery or weather patterns or whatever. So because of you saw us 3 judges, huddling, we must be talking about cases, right? I mean, we could be talking about, to the contrary, sometimes when people like stripes, you don't want to be talking about cases. We could be talking about, all the restaurants are not back open every day. It's hard to get a reservation, on a Tuesday. Where's the best place to get this, that? I mean, there's just a range of conversations, even though you might know we're 3 judges, they must be talking about the case. I just don't see how that follows.
Yes, Your Honor. I mean, to follow what we have to look at here is the context in which this huddle took place. Mr. Johnson, as a shop steward, served also as the union's agent, had unfettered access to these 3 particular eligible voters on the morning of the election. Normally, Mr. Johnson would be able to access the Exela workplace area because he would have the ability to pick up packages and of the like. Normal, customary kind of things. But in this case, he went to huddle with 3 eligible voters and was observed by another eligible voter.
Is the word huddle significant?
I believe, Your Honor, that the word huddle is significant because it signifies that...
In a football huddle, they're so gripped together, they've got to be talking about something surreptitious.
Your Honor, yes, I believe that is the case because at this...
Come on, counsel.
Well, Your Honor, to use the football huddle analogy, when football players huddle, before an offensive play is run, as it would happen at the Superdome, the intent of the huddle is to ensure that nobody else hears what's going on, and that is to conceal from...
Well, I just found it interesting to use the word huddle to somewhat connote that there's this, not just, as I said, could be talking about something else, but because of some close proximity, whispering, whatever. And I just want to say, is there really evidence of that, or is that just the shape, argument-wise, that's been put on this?
So the eligible voter who observed these 3 people together, I believe, used the term huddle in her testimony. But to the extent that we were worrying about the content of the speech, it's not relevant. It's really more of the impact it has on the other people who were observing this particular huddle. And it's not as even if the employer could have found out what the speech was that was being talked about, because to ask questions of employees as to what they were talking about could be considered to be an unlawful interrogation under the National Labor Relations Act.
Counsel, we are not the hearing examiner. You knew you were going to get some questions like this. We are not the hearing examiner, and someone could have perhaps found on your allegations and discussions that Johnson was a shop steward, even though there was someone who testified unequivocally that only two other, Callow and Exela, or I'm not sure about the pronunciation, were the only two people involved in organizing the union. So it could be that, you wouldn't believe Callow. And if you're the hearing examiner, you'd say, I don't believe you. I think this Johnson person was also involved, and they were doing some shenanigans, and so I'm going to find this not to be a proper procedure. But in fact, the hearing examiner and others found to the contrary. And why isn't that supported by substantial evidence if you have a person giving unrebutted testimony at the hearing?
Yes, Judge Ova. We believe that the board and the hearing officer and the regional director ignored evidence that would have militated against that finding. In particular, as you mentioned, those two paid union organizers, Mr. Archillo and Mr. Callow, it does not necessarily follow that they were the only two who could have had apparent authority or... Right,
it doesn't necessarily follow, but that's what the fact finder found. And so that's, when we're reviewing for substantial evidence, what would necessitate us reversing that?
Your Honor, I believe that the fact of the matter is that the board and the hearing officer ignored the fact that Mr. Johnson was the union's agent and that his conduct constituted objectionable conduct. And it's not as if only the two union organizers were the only ones who could have perpetrated objectionable conduct against the eligible voters in this particular case.
What is the overwhelming evidence that Johnson was the union agent?
That he was observed by another eligible voter, and she believed him to be part of the union and was an agent of the union at that point, and that she observed him huddling with those three eligible voters.
So that alone overrides the person's testimony that and makes us reverse, which is a high standard on this evidence review. Okay, is there anything else that you want to point us to on that?
As far as just the fact that this was a very close election, that it was an 8-6 vote, and that obviously the way the National Labor Relations Board elections work is that if one vote goes the other way, it would have been a 7-7 tie, and the union would not have been the winner of that particular election. So I think that the totality of the circumstances here support that particular issue as well.
Thank you.
There was one other point on this, Your Honors. The union did not call Mr. Johnson at the particular hearing, and the board, the regional director, and the hearing officer improperly failed to draw an adverse inference against the union for failure to call Mr. Johnson. Had it done so, Mr. Johnson could have testified to the fact that there was nothing sinister about the conversation that he was having with the three eligible voters that morning. But he did not, and the union did not call Mr. Johnson, even though he was within the same authority and the same, would have been under the union's control in that regard. There's one other objection here that I just want to...
Are you saying the company couldn't have required them to testify?
Because he was under the union's control, it would not be the company's obligation to do so. Not
their obligation, but if they think they're going to cross-examine him and really show that he's lying about his role, they could call him, right? The rules allow for that, don't they? Your Honor, I believe that the company could have subpoenaed him, although he would still be under the union's control, and the adverse inference rule would still apply for the union's failure to rebut the employer's evidence at the hearing. Right, okay. As to the second objection, the board and the regional director failed to correct the hearing officer's disregard of the fact that the union's representatives failed to adhere to the board agent's instructions
to promptly vacate the polling place. And rather, the evidence demonstrated the union's representatives languished in the adjacent parking lot, potentially visible to voters, without justification. Unless your honors have any questions, I respectfully rest on my papers and also for rebuttal.
All right, you have reserved your rebuttal time. Thank you, sir.
Thank you.
All right. Ms. Beard.
Good morning, I'm Heather Beard and I represent the NLRB. I'm going to be up here to address the board's decision on the election objections, and then my colleague from the Department of Justice, Mr. Tenny, for the Intervenor United States, will follow me to address the President's removal of former General Counsel Robb. And then finally, Katie Shaw for the Intervenor Steelworkers Union will address the issues raised in its brief. So here, as your honors were discussing with my colleague, I think this case boils down to a failure of proof on the part of Exela with regard to its election objections. And it's important to remember that here, Exela needed to shoulder that burden of proof all the way through, from particularly with Mr. Johnson's conversation with the employees, to demonstrate not only that Mr. Johnson was an agent of the union under the common law standards that this court has upheld, but that even if he was an agent, the conversation that he engaged in order to violate the peerless plywood rule has to be about election speech. I think that my colleague actually conceded here that we do not know what was said in that conversation. And under the peerless plywood rule, election speech is the only type of speech 24 hours prior to the election that violates that rule. So I think we can start there with regard to Mr. Johnson's conversation with the employees. To begin, first, under the peerless plywood rule, only a union or employer can violate it. So if Mr. Johnson is not an agent, if they did not demonstrate, as it is their burden, that he was an agent, then we don't have any violation of the peerless plywood rule. And here, it's important to remember, as our brief states, simply because Mr. Johnson was a union steward at a different company, at JLL, not at Exela, for a unit of employees that were not the unit being organized, that there is no proving that what you need under the common law, which this court has agreed with, is that the principal has given the agent duties that are with specific duties that are at issue have to be in the scope of what he did. And here, there's absolutely no evidence that as a union steward for JLL's employees, that Mr. Johnson, the scope of his duties had anything at all to do with organizing a unit of employees at a different employer, Exela.
Why didn't you call him as a witness?
I'm sorry, Your Honor?
Why didn't you call him as a witness?
Okay, first of all, it would be the union. And in this case, the union did not feel, or at least could have had, a good faith belief that Mr. Johnson wasn't necessary because they did, remember, they were the only ones who called a party to the conversation. That was Mr. Clifford Gray. And under the adverse inference rule, it is not appropriate to draw an adverse inference if the party who has the initial burden of proof has failed to meet it. So in this instance, when Mr. Schudroff's client, Exela, had the burden to show a violation of the peerless plywood rule, they called their employee, Ms. Rodriguez, who saw but did not hear the conversation, and then did not call anybody else who was a party to the conversation. Given the board's rules as to who has the burden of proof here, the union was under no obligation to call Mr. Johnson. However, it called Mr. Gray, one of the three employees who Mr. Johnson was speaking with, and that's actually the only evidence we have here, was that Mr. Gray said there was no talk about the election. So to the extent there was a witness for the union saying that there was no talk about the election, the Exela did not demonstrate in the first instance that there was, first of all, an agency relationship between Mr. Johnson and the union, nor that there was any indication just because they were talking together in the space that Mr. Johnson, as the record indicates and as the board found, he was regularly in that area. He was regularly talking to employees in that area. So the mere fact that there was a discussion between Mr. Johnson, who has no duties that have been proven with regard to the Exela election, is talking to three employees, doesn't mean that he was an agent and doesn't mean that they were talking about the election, particularly in light of Clifford Gray's testimony that in that conversation, Mr. Johnson didn't talk about the election. So that's with regard to the actual authority, which is necessary and not shown here, and the content of that conversation, which was not shown. Now, I also know you spoke about the apparent authority issue, which I'd like to address briefly. This court has recognized in the Conway decision that in order for there to be a demonstration approving of apparent authority, there needs to be a demonstration that it was actually the principal, here the union, that placed the purported agent in a position where employees believe that that person was acting as an agent on behalf of the union. And here, there's absolutely no evidence that any belief that Ms. Rodriguez had about who or what Mr. Johnson was or what he was doing with regard to the union, that any of that came from someone in the union. So in order for there to be even apparent authority for someone to think he was an agent of the union, there would have needed to be some representation from the union to Mr. Johnson that he was representing them with regard to this bargaining unit at a different employer. And that evidence simply doesn't exist. So for both of the reasons that we don't know that the union did anything here, since there was no proving that Mr. Johnson was a union agent, and because there's no proving what the conversation was about, and if anything, it wasn't about the union, what we're left with here is yet a third finding by the board, which is that even if you assume those things, assume he was an agent, assume that they were talking about the election, the kind of conversation that took place in the sense that there were 3 employees and someone from the union briefly speaking an hour before the election, that alone is not the type of a massed assembly that the Peerless Plywood Rule speaks to or prohibits 24 hours before the election. I mean, indeed, should we go with sort of the rule that's being purported to be established by my opponent here, under the Peerless Plywood Rule, this applies to employers as well as it does to unions. So 24 hours before the election, an employer would not be able to speak to more than one of his or her employees about anything, perhaps even in a huddle, because that would then mean that somehow there was a violation 24 hours before the election. And that is simply not the case. I mean, Peerless Plywood applies to massed assemblies where employees are unable to leave, that they have been summoned to. And as the evidence showed in this case, even assuming agency and assuming, again, I don't think you should, but even assuming they had proven that this was about the election, this conversation was not in an area where, at least there's been no proof, that the employees, although they were in their work area, they're in this big warehouse, Mr. Johnson regularly comes and picks up packages, and he speaks to some of these employees. That type, even if it was about the election, the law is clear in the cases that we cite in our brief, is that the Peerless Plywood Rule is not there to prohibit every minor conversation between employers or unions and voters 24 hours before the election. And so under Peerless Plywood, the board absolutely was well within its discretion in determining that the conduct that morning was not objectionable. And so to then go to the second election objection, the board also was correct in finding that under either its Milcom standard or Boston insulated wire, which was a board decision upheld by this court, that the 2 union organizers, Mr. Clement and Mr. Archilla, prior to the election at the polls, standing for, all the evidence shows, at the very most, at 9:59, 1 minute before the polls open, standing 80 feet from the entrance to where the election was taking place in the back of a different building, them standing there for less than a minute with no evidence, or at least at most a minute, with no evidence that anyone saw them standing there, under Boston insulated wire, as the board found, that was not something sufficient to demonstrate the standard as the company was required to, that it tended to interfere with the voter's choice in the election. And so the board's urging this court that based on the 2 election objections, the will of the voters in this election should be given effect. And I suppose the last thing I'll say is my opponent mentioned it was a close election. The mere fact that it's a close election does not mean that an election gets overturned. There has to be a valid objection here. And I think as we have established, there weren't any objections in this case that were sufficient to overturn the vote in the election that took place back in 2019. So we urge the court to enforce the board's order. I see I have 18 seconds left, but if you don't have any other questions, I'll turn it over to Mr. Tenny.
All right, thank you, Ms.
Thank
Beard. Mr. Tenny?
May it please the court, Daniel Tenny from the Department of Justice. In Collins last year, the Supreme Court addressed a situation in which one provision of a statute provided protections against removal, and a second subsection in the same statute for a different officer omitted those protections and held that in those circumstances, the longstanding default rule that the president has authority to remove officers at his discretion applied. And that same principle applies here. Here you have subsection A, which applies to members of the board and provides that there is a limitation that they can only be removed for neglect of duty or malfeasance of office and no other cause. And then
United States' position at this time that in any agency that someone who is serving a term, if it does not explicitly contain protections for removal in the adjacent statutory authority or regulation, that they can be removed before completing their term. Does that apply across the board in any agency in the United States government at this time?
I'm hesitant to make a totally categorical statement. I do know that the fact that there's a term of years and nothing else was held over 100 years ago in Parsons not to be sufficient to provide any protections. If there was some particular feature of a statutory scheme that made it clear that there were supposed to be protections, but here everything points in the opposite direction.
So even though this was not ever the practice, and that it was being in this agency, well, numerous precedents allow the person to fill up their term as the counsel, and this is changed recently, that people are being let go before their term in a variety of agencies, and that's perfectly acceptable, even though the tradition was not to do that. Is that correct? And so it's the government's position that anyone can be removed absent defined protections against their removal, even when they're appointed for a term?
Well, I mean, you spoke of tradition, and it is true that there may be political accommodations between the president and Congress, or understandings about when the president might choose not to exercise removal authority that he has as a matter of law. But if the question is, unless there's something in the statute that as a matter of law precludes the president from exercising this authority, then yes, we think the president's at liberty to exercise it.
So the specification of a term is somewhat superfluous because it's always removal at the will of the president?
Well, again, the Supreme Court addressed this in Parsons in the late 19th century, and said that the term does have a legal effect, which is that at the end of the term the person leaves office, whereas if there's no term, then the person continues until they're removed.
No protection whatsoever.
That's correct, and the Supreme Court analyzed this at considerable length in Parsons and talked about how, at the time of the framing, there were debates about what the removal power should be, in what circumstances the president could remove an officer from office. It talked about the fact that there was a term of years in that case, and said that did not supplant the president's authority to remove, and that the legal effect of the term of years was only that the person person's term would end at the end of those years, even absent any action by the president. The idea that the term of years was the reason that there was a removal protection here wasn't even discussed in the opening brief, and then in the reply brief they don't point to any authority in the other direction. The only case we have before the court specifically on that issue is the Parsons case, which addressed, that was a United States attorney, a term of 4 years. The president decided, no cause, just decided, would prefer to have the president's own selection occupy that post. And the Supreme Court said that that was okay.
In Collins, which you mentioned right off the bat, that officer did not have confirmation by the Senate, correct?
The acting director did not, that's correct.
Right, that officer did not have confirmation by the Senate, and this one did, the general counsel, correct?
That's true.
Does that matter if it's a confirmed position for a term? Rather, has there ever been a case that's held a confirmed position for a term can be removed prior to the term? Has there ever been a case that has held that?
Well, Parsons held exactly that.
Exactly, confirmed by the Senate for a term.
Correct.
Okay, and so Parsons, and you believe it's controlling today?
Yes.
And so we don't need to talk about Collins or anything, we just need to talk about Parsons. Is that right, to answer this question?
To answer this question, that's correct.
Okay, thank you.
Unless there are any other questions. Thank you, Your Honor.
Thank you. All right, Ms. Shaw from Steelworkers.
May it please the court, I'm Katharine Shaw on behalf of the intervener United Steelworkers International Union. In this case, the board acted well within its discretion when it determined that the 2 objections made by the company were without merit and insufficient to warrant setting aside the election. As to the first objection, Fred Johnson is not an agent of the union. The board correctly found that there is no evidence in the record that Johnson's status as a Jones-Lang-LaSalle shop steward established a relationship between him and the Exela bargaining unit in which he was authorized to act on behalf of the union. Exela failed to show that the union placed Johnson in a position where he appeared to act as its agent with authority to organize the Exela employees. Johnson was not involved at all in organizing the Exela employees. Johnson did not give an election speech or speak to a massed assembly on election day. Opposing counsel stated that the content of the discussion was not relevant. However, the peerless plywood rule explicitly prohibits only election speeches, not all speech within the 24 hours before a representation election. There's no evidence in the record that the election was discussed when Johnson was talking to the 3 Exela employees, and the witnesses that Exela did call had no firsthand knowledge of what, if anything, Johnson said to those employees. The board also reasonably found that Johnson's interaction with the Exela employees on the morning of the election was consistent with his regular daily visits to the warehouse receiving area in the course of his job duties. The record testimony established that Johnson visited the warehouse on a daily basis to look for and retrieve packages for his employer, Jones-Lang-LaSalle, and that he regularly had conversations with the Exela employees while he was there. As to the electioneering objection, the company claims that union organizers Arturo Arquila and Brian Callow engaged in improper electioneering on election day in the parking lot as they left the facility upon the conclusion of the pre-election conference with the board agent and the company representative. However, the record shows that they did not engage in any electioneering. They were 80 feet away from the entrance to the polling site. They were not present in any designated no electioneering area. They left the parking lot 1 minute before the polls opened, and there were no complaints of any kind about their brief presence in the parking lot on the day. There's also no evidence that any voters saw them in the parking lot or spoke to them. The board reasonably concluded that the company failed to show that Arquila and Callow somehow interfered with the employee's exercise of free choice at all, and certainly not to such an extent that their presence in the parking lot materially affected the results of the election. I see my time is almost up. In closing, the evidence does not support the company's objections, and the board order is entitled to enforcement. Thank you.
Thank you. All right. Back to rebuttal, sir.
Thank you, Your Honors. First, to go to the Department of Justice's point concerning the Parsons matter, I believe that case dealt with U.S. attorneys who, unlike the General Counsel of the Labor Board, do not work inextricably with the members of the multi-member body agency with whom they're associated with. In other words, the U.S. attorney and the Article III judges who they would appear before.
Did either the government or you cite that case to us?
No, Your Honor.
So the government's seminal case that they say is the silver bullet they raised for the first time today in oral argument, and you didn't cite it in your reply brief either.
I did not, Your Honor.
Okay, well, we normally have a rule that you're not supposed to rely on cases without discussing them. Anyway, but you have to respond under the circumstances.
Yes, Your Honor. I mean, just to briefly touch that point, I mean, and I'm just trying to draw the dichotomy between the two as far as the issue between a U.S. attorney and an Article III judge, and by contrast, the General Counsel's office, or the General Counsel, I should say, and the National Labor Relations Board. Again, you know, the General Counsel can't, the National Labor Relations Board, the 5-member board, can't act absent a complaint. And I don't know if that actually has the same kind of effect between an Article III judge and the U.S. Attorney's Office. There are other Supreme Court cases which both parties did cite, and those include Humphrey's Executor, where the Federal Trade Commission Act fixed the term of office, so there was no concern about a lifetime tenure, which I guess the Supreme Court had ruled was a problem.
But to be clear, you're not caught off guard. You are familiar with Parsons, right?
I am familiar with the Parsons matter.
It's a slightly different deal. Judge Elrod's point is well taken, but it's not like when we get somebody who brings something, you know, out of left field nobody's ever heard of. It is the better part to give the cases to us. But on the other hand, it's one of the reasons why we have oral argument in some of these cases. It helps us shape the issues and fish out what counsel, for reasons best known to them, don't tell us to get the right answers. So we'll look at it, but all are advised, you know, in the future, put the cases out there, you know, initially if they bear on the point. But you're not caught off guard, so we don't have an issue about that.
You're
right.
I won't say that I heavily reviewed the Parsons matter because it wasn't cited in the brief.
But you knew it was a U.S. attorney case, and it was somebody who was confirmed by the Senate, et cetera, et cetera. There's nothing about it that counsel opposite said that you disagree with, right?
I don't.
Not his take on it, but in terms of what it involved.
Correct, Your Honor. I am familiar with the very brief underlying facts.
All right, that's fine. Keep going with your ball. I don't want to take you totally off track. I just want to add that little piece to the whole conversation.
Yes, Your Honor. And I just also wanted to mention the Wiener case from the Supreme Court, which dealt with the War Claims Commission, which had no term of years in the statute, but the commission itself was designed to be temporary, so there was no concern of life tenure in that case either.
So is that one in your brief?
Yes, Your Honor.
Good. Good.
But both Shurtleff, which is the 1905 case, Humphrey's Executor, Wiener, Collins v. Yellen, and Seal of Law, all of them were cited in the brief. Going to cited in the reply brief. Going back to the discussion that Ms. Beard and Ms. Shaw had concerning the underlying peerless plywood rule. It is true that the peerless plywood rule applies to employers and unions alike concerning election speeches. But this is a unique set of circumstances here, and I think the board, in its underlying decision, missed it. And that is that in this case...
Doesn't it get you back to the very salient question Judge Elrod asked you to start with? Substantial evidence in the record is where we start and where we end. And so we get it, you're saying they ignored this, bloody, but you're still left with that as the standard, right? Well,
the substantial evidence would still be the standard, but I think there's also a legal issue here as well, Your Honor, which is that there is an imbalance here between unions and employers in that sense, because
But that's a policy issue.
well, it may be a policy issue, but it's still applicable here, Your Honor. And the point is that the employer can't inquire of employees what the actual content of the speech was between a union representative and the employees, because to do so would...
You said what was said didn't matter.
Well, that's, Your Honor, it doesn't matter. That's right. The content of the speech is irrelevant, but the fact of the matter is, even if the employer wanted to figure out what it was, it wouldn't be able to do so, and that's exactly why the content of the speech does not matter in the circumstances. It's the actual act itself. And I see my time has concluded.
Thank you, friend. I'll give you one good declarative sentence to round it out. No commas, no semicolons.
Thank you, Your Honor. Thank you, Honors.
All right, you didn't take it. All right, well, thanks to counsel for the briefing and oral argument of the case. This case will be submitted and we'll get it decided. The panel will stand a brief recess while we reconvene to hear the Janvey case, and following that will complete the docket for today. So on the record, following the completion of arguments in the Janvey case, that will complete the session for this panel for this week, and thereafter the court will stand adjourned. So for now, we stand in recess.